firm. And then I think a few weeks after that, you appeared on another case.
Yes, Your Honor, and we submitted a motion to substitute counsel on that case. And we will on this case as well, Your Honor.
Also, you haven't submitted a motion to sub?
I don't believe we have yet, Your Honor, but I will get with our paralegals.
I think that's
That's for
down.
Joey Cantu. I have one for Joey Cantu that's gonna be taken.
We will file a new one, Joey Cantu.
Is that the motion to sub on, was filed by, when was it
This one
filed?
was filed in 20.
So that was Donald had filed those. Okay,
But we will file a new one, Your Honor. We'll get with our paralegals so they file that. We understand that a motion to substitute counsel is required.
all right, right, in each, in those cases. Now, so, let's see. How do you pronounce your first name?
Otoniel.
Otoniel?
Yeah.
Like,
Otoniel.
Otoniel. Okay. Now, your last name is Maldonado?
Yes, sir, Maldonado.
How you doing, Mr. Maldonado?
Doing good.
That's good. Now, as you heard, your attorney of record is Attorney Artie Donald. And Attorney Donald is no longer with the law firm that he was working for.
Yes, sir.
And so your attorneys that's here now, they're going to file what is called a motion to substitute. They're going to substitute in for him so that they can represent you. Do you understand that?
Yes,
Okay, okay. And so at this point, we're unable to do anything other than reset the case.
yes, Your Honor, if we could please reset the case.
Yeah.
We can file that motion to substitute counsel and go through discovery with Mr. Maldonado, who we've already had some productive conversations with, but
Okay. Give us how much time do y'all need?
if we could have a month, Your Honor.
Okay,
It'll be August 6th.
August 7th is the reset date. Okay, and to give you opportunity to file your motion to sub.
Yes, Your Honor, thank you.
You're welcome.
May we be excused?
Yes, you may be excused. Oh, once you get your reset, you'll be excused.
Yes, Your Honor, thank you. very
Okay,
much.
all right. Y'all have a blessed day.
Thank you.
You're welcome. And I need to get y'all name. We need to get their name so we can write it on the document. Okay, Mr. Vasquez, your client is currently on Zoom.
Yes, Your
You
Honor.
ready to proceed on your cases?
Yes, Your Honor.
Mr. Sutton, you can take your mic off of mute.
How you doing this morning, Judge?
I'm
Judge
doing
Holmes?
fine. Now, your full name is Jalen David Welcome Sutton?
Yes, sir.
Okay, now, Mr. Sutton, we have three cases. First case is cause number M326302, cause number M326304, and cause number M326306. All three cases are styled the state of Texas versus Jalen David Welcome Sutton. Mr. Sutton, you represented in your case by your attorney Joe Vasquez, who is currently present in court. Mr. Vasquez, how are you doing?
Good, Your Honor. How about yourself?
I'm doing fine. And the state is represented in these cases by Attorney Kobe Hallfire. Attorney Hallfire, how are you doing?
Good, Judge.
Mr. Vasquez, what is your announcement in Mr. Sutton's cases?
Your Honor, we're requesting that these cases be put on the trial docket. There may be I don't think an information's been filed. I'm not aware. There may be.
Yes, sir. Judge, can I say something?
Yeah, hold on a minute. You say you don't think information has been filed. What you mean by there's another case that's gonna be filed? That's what you're saying?
3 right now.
We have three
No.
cases.
Are there any more coming in?
No, sir. Judge, can I say something?
Mr. Sutton, don't speak right now, okay?
Yeah, Mr. Sutton, you have a right to remain silent. Anything that you say can and will be used against you in a court of law. Anything, so at this point, you have an attorney and so, I mean, if you want to talk to your attorney beforehand, tell him what you want to say. Other than that, your attorney has made announcements to place these cases on the trial docket.
There is a note on the docket that says there's a new case that's 23 CCCR 0310. That's not on the.
It's on the, oh yeah, I see it right here. What?
It's
Okay,
not on our docket, it's just noted in the.
that should be added to. Should have been added to the docket. Hold on a minute. Could you look that case up?
Wow, this is crawling. Yeah.
What did you say?
I said, probably wasn't good on the docket because I wasn't.
Well, one has to be issued.
Yeah.
Okay, the DA's office nominee. Okay.
Another.
Okay, so there's another, is,
Criminal
what
trespass.
case, it's a trespass?
Yes.
Okay, so Mr. Welcome Sutton, there is another case that has not, well, you haven't been arrested on it.
Of course not.
Yeah, so that case, the warrant act is gonna be issued. And then that case will also be with these, three other cases.
Wait a minute, Judge. Hold on. You said a warrant will be issued for what?
The new case, anytime a new case is filed, a warrant is issued on the case. The warrant has not been issued on that case. Now, according to what,
But hold on. I went to jail. When I went to jail, they charged me with 4 charges. I got charged 4 charges. On my bonds paper is 4 charges. So now I get an additional warrant for what? Like they already charged me.
Sutton, I advise you just.
There's something wrong with the court system. That has nothing to do with me. Like they had already charged me. That stuff was already in my paperwork. Now I have to go back to jail.
Sutton, just listen today. Just listen. We can talk about all this later.
okay, right now, we're just trying to see what's in the computers, and I think the coordinator, she's looking in the computer and she did not, she had,
We're gonna call downstairs, county clerk is
Oh,
behind on bond.
okay. So I was just informed that they're gonna call the county clerk's office because they right now they're behind on the bonds. So there is a possibility that they did not put it in the computer yet. So, and if that's the case, a warrant will not be issued because the warrant has already been executed.
Right.
Okay, that's,
Okay.
but I'm saying nothing is in the computer right now. So we look at, the court coordinator is looking at the computer. And so
But
somebody
Yes,
has
sir.
to input that data, and she's calling downstairs right now to see
Okay.
if the paperwork is there, and if it is, they're gonna put it in the computer.
Okay. Because I'm telling you, they have already charged me. That's what I went to jail for. They
Understand?
charged me, and then see, I wasn't even supposed to get that but I digress. All I'm talking about right now is that they extra
I
charge.
understand. Okay, I understand what you're saying. You don't have to keep repeating it over and over.
Okay.
Just Yeah, they're checking into it right now.
Okay. Thank you.
Mhm. So right now, they're still looking into it. It's gonna probably take them a while. So in the meantime, your attorney has announced that he wants these cases set on the trial docket. Is that correct?
Yes, Your Honor.
So the cases are gonna be set on the trial docket. Your attorney, your bondsman, will be given notice of your resets. Stay in contact with your attorney, your bondsman. You're free to go. Mr. Welcome Sutton, and you have a blessed day.
Okay, Judge, can I ask you a question?
Okay.
How do I get into contact with my attorney? Because I need to talk about my trial.
Okay, hold on a minute. Did we, you appointed?
We're in.
Yeah, I have a court-appointed attorney.
No. I'm saying, but you still have the paperwork that was given to you when you were in court, when your attorney was appointed?
Yes, sir. I call that number all the time. There's no answer. Like
Well,
I've been trying to talk about my case, and like I have no communication until the day of my court.
okay.
The same number you called me on this morning, Mr. Sutton.
Okay, so when are your best times that you'll be available, Mr.
Okay,
Vasquez?
let me do this here. You can call him and he could discuss that with you over the telephone. We are currently in court on YouTube, on
Okay.
Zoom, and so you need to call your attorney to discuss those matters, okay?
Okay.
So this time your case will be reset. What is that? You have a reset date? Yeah, he said a jury trial. July 31st? Okay, your case will be set for trial July 31st. Stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
You too. Have a blessed one, Judge Holmes.
Thank you.
Thank you.
You're welcome. You're welcome. I think that's the only. Yes. Jefferson County Court at law number 2 is back in session. The court is in session in cause number M331142. The case is styled the state of Texas versus Cedric Denzel Brooks. Mr. Brooks, is that your full name? Mr. Brooks, would you please raise your right hand? Mr. Brooks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Brooks, you may put your hand down. How are you doing, Mr. Brooks? That's good. Now, Mr. Brooks, you're represented in your case by your attorney, Attorney Marva Provo. Attorney Provo, how are you doing? Ms. Provo, do you waive a record in Mr. Brooks' case?
Yes, I do.
Mr. Brooks, I have before me a document that is titled Information. This information alleges that on or about October 25th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Brooks, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Brooks, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Sure.
Okay, Mr. Brooks, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials CB that are on the line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Have a discovery certificate. I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Brooks, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you read and understand everything that she went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Brooks, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavit, which is in the court's file. State, would you like to offer State's Exhibits 1 and 2?
Yes, Your Honor.
Any objections? No objection, State's Exhibits 1 and 2 are admitted. Mr. Brooks, your attorney, Ms. Probo, has advised and counseled you. Were you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
And Ms. Provo, you've advised and counseled Mr. Brooks. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Brooks, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is that agreement?
The state will plead of guilty no contest. The state should be to recommend 30 days in Jefferson County Jail and court calls. Then that's credit for 2 days, and I believe he's going to report on June 23rd at before 6 p.m.
Let's see, okay, see report. June 23rd. Before 6 p.m. Mr. Brooks, the state is offering that you serve 30 days in Jefferson County Jail. You'll be given credit for the 2 days that you've already served. The court cost in this case is $287. Will you be able to pay the $287 court cost? Okay, I think we have, well, could you give me a copy of his affidavit of injuries? They don't, and they say I can't view it. I don't understand how it says that. I don't know why. Mr. Brooks, could you show this document to your client? Mr. Brooks, your attorney is showing you a document that is titled Affidavit of Indigence. Do you recognize that document?
Yes, sir.
And on page 2 of that same document, at the top to the left, is that your signature above the line that is titled Defendant Signature?
Yes, sir.
Now, Mr. Brooks, is everything in that document still true and correct today? Regarding your finances?
Yes, sir.
Okay, now, Mr. Brooks, the court is going to find that you are indigent. And based on the finding of indigence, you will not be required to pay the court costs in this case because the court cost is going to be waived pursuant to Article 42.15 of Texas Code of Criminal Procedure. Now, Mr. Brooks, your jail time is to start on June 23rd of 2023 at or before 6 p.m. And you need to report to the Jefferson County Jail. Do you understand that?
Yes, sir.
All right. Please stand next to your attorney on the X.
Sorry. Let's do the 2 for 1, right?
You have to talk to the jail about that. The jail handles the jail time. All right. Now, you're going to stand in front of our court clerk right here to my right
Right here.
and follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
All right.
And yes, Ms. Provo, you may be excused and you have a blessed day. This is cause number M 333384, case of style of state of Texas versus Kyrie Richard or Kyrie Richard. How do you, Richard? How you doing, Mr. Richard? That's good. Mr. Richard, you're represented in your case by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
Great, Judge, thank you.
Mr. Gertz, what is your announcement in Mr. Richard's case?
Judge, we're going to ask for some additional time here. This is our first appearance on this case, and we're still gathering discovery. There's a number of videos in the case we're going to need to watch and some other things.
Oh, it is?
Yes, Judge.
Okay. Now let me do this here.
Judge, I don't know if he's been arraigned or not, but we would waive arraignment in this case.
Oh, okay. That's probably, okay.
That may.
Let me, give me some bond conditions. Give me the second, the folder that doesn't have the, yeah. Yeah, okay.
We'll waive reading the
Okay,
information
okay,
and or plead not guilty of this.
okay. Let's see, should have had a stand. Need to just have a seat. I need to give him some bond conditions. I'll call y'all back up and give him some bond conditions. Shouldn't take but a few minutes to do that. Here we go. Yeah, I need to give him some bond conditions. Just have a seat. I need to draft him right quick.
No. Keep it.
Okay. Mr. Richard, could you hand this to your client? Mr. Richard, I just handed you, your attorney, some standard bond conditions in County Court at Law number 2. I'm gonna go over these conditions with you. The title of the first page is Standard Bond Conditions in County Court at Law number 2. Do you see that title? And it reads as follows. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And I think condition number 2, number 3 does not apply. Condition number 4 does not apply. Now, condition number 5 does apply and say the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 107 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of the state agency or political subdivision. Do you understand that condition? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest. Do you understand that? Now, your case is going to be reset. You want it on the announcement document, is that correct?
Yes, Judge.
Give us about 60 days. That
Yes,
should be enough. On August 9th, okay. Mr. Richard, your case is gonna be reset to August 9th. Your attorney is gonna get a copy reset from our court administrator. Once you get a copy reset, you'll be free to go and you have a blessed day. All right. And you'll be free to go as well, Mr. Gertz. Eddie Dixon,
Thanks, Judge.
you're welcome. You have a blessed day. Good morning. This is cause number M333986. The case is styled the state of Texas versus Eddie Dixon. Mr. Dixon, is that your full name?
Yes, sir.
How are you doing, Mr. Dixon?
Okay.
That's good. Now, Mr. Dixon. Let's see. Judge's explanation, all right. Okay. Mr. Dixon, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. And on this document that was signed by you on April 4th of 2023, you initialed the line that stated you wanted to apply for, that you wanted to hire your own attorney. Have you hired your attorney?
I talked with Mr. Langston Allen. He had asked me how you could reset it, so, because we had just started.
So let me ask you this, are you hiring an attorney?
Yes, sir.
Okay,
I'm trying to hire him, so I don't know what's the procedures, but I was trying to get him to come. and
let me,
represent me.
well, okay.
But he-
How much time do you need to hire your attorney?
About 60 days or something at the most.
Okay, okay, resetting for 60 days?
So I should know somebody.
Okay, this case is gonna be reset to August 4th to give you an opportunity to hire your attorney.
Yes, sir.
You can get a copy of your reset from our court coordinator. Once she gives you the reset, you'll be free to go. You have a blessed day and stay in contact with your bondsman.
Thank you, Mr. Brown.
You're welcome. Next, we have We ready on, is it Martinez? Juan Martinez?
Yes, Your Honor.
Let's see. Let's see. Martin. Jefferson County Court at law number 2 is back in session. The court is in session and calls number M328134. Case is style of State of Texas versus Juan Jose Martinez Jr. Mr. Martinez, is that your full name?
Yes, sir, it is.
Mr. Martinez, would you please raise your right hand? Mr. Martinez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
You may put your hand down, Mr. Martinez. Mr. Martinez, you're represented in your case by your attorney, Zanega.
Yes.
And Mr. Zanega, how are you doing?
I'm feeling well, Judge. Good morning.
Good morning. Mr. Zanega, do you waive a record in Mr. Martinez's case?
We do so, Your Honor.
Okay. Mr. Martinez, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Juan Jose Martinez Jr., on or about September 18th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Martinez, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Martinez, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Mr. Martinez, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials next to, on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir, I did.
On the next page of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
At the top of the same document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Martinez, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir, it did.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, yeah.
Mr. Martinez, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, would you like to offer State's Exhibit number 1 into evidence?
Yes, Your Honor.
No
It-
objection.
No objection. State's Exhibit number 1 will be admitted. Attorney Zanega, you advised and counsel Mr. Martinez. Is there any evidence that he is currently mentally incompetent to stand trial?
He is competent.
And Mr. Martinez, your attorney, Mr. Zanega, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, I am.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Martinez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your waivers, your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for plea of guilty or no contest, the state decree recommended 15 days in Jefferson County Jail and court costs. The defendant has credit for 15 days. We ask this to be time served and back for retirement.
Mr. Martinez, the state is offering that you serve 15 days in the Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail on this case because you've already served 15 days in the Jefferson County Jail. The court cost in this case is $342, but you will not be required to pay the $342 court cost because the time that you have spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. Mr. Martinez, do you understand the state's offer?
Yes, sir. Yes,
And do you think that the state's offer in your case is fair and just?
yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Martinez, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Martinez, this will conclude your case. You're going to stand on the X in front of our court clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
And Attorney Zuniga, you'll be free to go as well. You have a blessed day.
Thank you.
You're welcome.
Later.
You're gonna have to do
Yes,
my
yeah.
time. All right, yeah, okay. Okay. Thank you, sir. Have a good night. Thank you.
Rory Parker. Yeah. Okay, Mr. Parker, this is cause number M333174, case of South State of Texas versus Rory Parker. Mr. Parker, is that your full name?
Yes, sir.
How you doing, Mr. Parker?
I'm good. And you?
I'm doing fine, thanks for asking. Now, Mr. Parker, your case has been reset for you to hire an attorney. Have you hired your attorney?
The attorney I have on hiring, he's on vacation.
Okay, and who is that?
Mr. Richards. I believe.
Richards.
Buddy Reynolds?
Yes.
Reynolds?
Yes, yes.
Oh, okay. All right. Let's reset him. We're gonna reset this case for 30 days. Okay. At that time, you need to have your attorney in place
Mhm.
because you've had at least 7 months, right?
Yes, sir.
Yeah. So this is your last reset to hire.
Okay.
All right. Go ahead on and resetting for 30 days. We're in July. Well, okay. It's gonna be reset July 12th. 23. Now, if you when you hire your attorney is going to send a letter of representation to the court,
Mhm.
and then he's probably gonna get it reset from this date.
Oh, okay.
But he'll tell you that. But
Yes.
we need to get the letter of representation before this court date. Okay,
Okay, thank you, sir.
all right. Once you get your reset, you'll be free to go and you have a blessed day.
You too.
Adrian Shaw. This is cause number M333992. Case is styled the state of Texas versus Adrian Imran Shah. Mr. Shah, is that your full name?
Yes, sir.
Mr. Shah, see that on April 5th, your case was reset to give you an opportunity, or April 4th, to give you an opportunity to hire your attorney. Have you hired your attorney? Why haven't you hired your attorney?
I just wanted to talk to the prosecutor like I did last time. With the options that he gave me.
Well, you're gonna have to give him another judge's explanation and a waiver of counsel to fill out. Just have a seat, and you can have a seat right there at that table. He'll give you the forms that you need to sign. Victoria Smith. This is cause number M333686. Case is style the state of Texas versus Victoria Smith. Ms. Smith, is that your full name? Okay, how you doing, Ms. Smith? That's good. Now, Ms. Smith, your case was reset on April 11th, 2023 to give you an opportunity to hire your own attorney. Have you hired your attorney? And why haven't you hired your attorney? What, you just started working? Okay. We're gonna reset it 60 days to give you an opportunity to hire your attorney, okay? So you're gonna stand in front of our court administrator. Once she resets your case, you'll be free to go and you have a blessed day. Jermaine Paul Beverly, please come forward. Come forward. Now, Mr. Beverly, your full name is Jermaine Paul Beverly, is that correct? Mr. Beverly, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document? And is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials online stating you want to waive your right to attorney and represent yourself? I also have another document here. This document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
No.
And is this your signature on the line as titled defendant?
Yes, sir.
Now, Mr. Beverly, before you signed and initialed all of these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? All right, Mr. Beverly, just have a seat and the prosecutor will talk to you.
Judge, I think I've talked to both these individuals before at the pro se arraignment document. I'm not sure what else I need to talk to them about.
I mean, I can't tell you that either. I mean, you
Yeah.
can talk to them and find out.
That's what I'm saying. Like, I don't feel comfortable again approaching as a pro se. We're already done once. If they need you to get a lawyer or they need to plead to the court, me talking to them again and going back over the same thing where I did at arraignment, I think it's counterproductive. And as far as what I'm doing, we've already done it once. Doing it twice puts me in an ethical dilemma, Your Honor. That's my concern. Because it is a pro se.
Oh,
and it is
hold on a minute.
at the state.
Okay, hold on a minute. Okay, that's like that, okay. Okay, now, Mr. Beverly, you come back up. The prosecutor in this case has indicated that I guess he has already talked to you about the case or something. Well, I guess at one point you had waived your right to an attorney.
Yeah.
And then after you talked to the prosecutor, you changed your mind or something. No, I'm just asking you a question.
Yes, off the,
Okay, I don't need to know what he offered. My question is, you have already talked to him about the about your case. I mean, but you talked, did you?
yes,
Yeah,
yes,
okay, you
sir,
talked
yes,
to
sir,
him.
yes.
Okay, so he's indicated to the court that he's not willing to talk to you again about working out a plea bargain agreement. Okay, and so I think when you are arraigned by the court informed you that, one, you had a right to have a trial by jury. Well, first of all, you had a right to have an attorney, and that you could either hire an attorney if you can't afford to hire one. Then the next option will be you can request that the court appoint an attorney to represent you. Or number three, you can waive your right and represent yourself. And apparently you did that the first time, and you were not able to reach a plea bargain agreement. And so you changed your mind and asked for your case to be reset to higher. Okay. And so that is what brings you here today, because you informed the court that you have not hired an attorney. Is that correct?
Yes, sir.
Okay. And so at the hearing for the arraignment, the court also informed you that you had a right to have a trial by jury, and you could waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And then by doing so, your case will come before the court in one of three ways. One way it will come before the court is by way of a bench trial. A bench trial is if you want a trial, but you don't want to have a jury trial, you just want to have a trial before the judge. We call that a bench trial. The other way your case can come before the court is by way of an agreed plea bargain agreement, an agreement that you work out with the state or the district attorney's office. And I also inform you that the third way your case can come before the court is by way of an unagreed plea bargain. And what an unagreed plea bargain is, it basically means that you and the state have not been able to reach an agreement concerning your case. And therefore you want the court or the judge to assess the punishment in your case. And the punishment will be assessed within the punishment range for your particular offense. Do you understand that?
Yes, sir.
So at this point, you are saying that you want to represent yourself. The state is unwilling to renegotiate or get into an offer, a plea bargain agreement to you.
And I just want to make clear, Judge, like, because our dilemma is that we've already done that, and then you see what I'm saying? We've done that at another time. We go back again is what the state.
So I guess what he's saying is whatever that offer was, he's not changing it.
It's not
right?
changing.
It's not changing.
It's either accepted or not, but if I don't know what he did. I can't, because I can't remember every one of them, but if he changed it to, he wanted to go higher, which sounds like he said, that's my problem with going to looking higher. And then now he wants to come back and talk to the state. That's where my ethical dilemma comes from. Then we're going back to the state and pro se, it's an issue that I'm uncomfortable doing as with a pro se who went to hire
Well,
back and forth.
apparently,
It's-
you wanted to say something?
Yes, well, we really need.
Well, okay, I don't want you to talk about what you and the prosecutor negotiated. Okay, I'm not, we can't get into that,
Okay.
okay?
Yeah.
So we can't get into what the negotiation, what that negotiation entailed, okay? So at this point, I mean, you have a constitutional right to waive your right to an attorney and represent yourself. That's a right that you have. You have a right to hire an attorney if you desire to hire, or you have a right to see if you qualify for a court-appointed attorney if you cannot afford to hire an attorney. Okay. So now what do you want to do?
I just applied for attorney.
Okay, so let's he needs to change this form and then just have a seat. And he's gonna give you you have to fill out what is called a financial affidavit. Okay. Yeah, you go home, get those back. Mr. And that's Mr. Shaw. You come forward. Just have a seat. Okay, this is cause number M333992. Case of style of state of Texas versus Adrian Imran Shaw. Mr. Shaw, is that your full name? Okay, now Mr. Shaw. Let's do this here. Let me get your. Now, Mr. Shaw, you previously appeared in court, and I have before me a judge's explanation of defendant's right. No, judge's explanation of rights to defendant without an attorney. And the first, well, I have one in my hand, and I also have one in the file. The one in the file was dated April 4th of 2023. And the document that I'm looking at, it has your initials on, well, you had your initials on 4 lines. 3 of the lines were scratched out.
Yes.
And then the line that was not, okay, the line that was erased was, I want to apply for court-appointed attorney, court-appointed counsel. Then it was scratched through, I have a court-appointed attorney whose name is blank. And then I want to waive my right to an attorney and represent myself. That was also scratched through. So at some point, I assume that you wanted to apply for court-appointed attorney first?
I just want to represent myself.
You just want to represent yourself? Okay. And then at some point, you wanted to apply for court-appointed attorney, that was scratched through. Then you decided on you wanted to reset this case to hire your own attorney. And I assume that happened after you talked to the prosecutor about your case. Is that correct? Okay. So the prosecutor in this case, Mr. Hallfire, has stated to the court that he has already talked to you about the case and that he feels uncomfortable with talking to you again about the case. And he's, I guess, not willing to, renegotiate or negotiate any further from what he's not willing to say anything else, anything different from what he said the last time regarding this case. Okay?
Yeah.
So now, if you're going to make a statement, I don't need to know the details of what you and the prosecutor talked about?
No, I was gonna say, does it matter if I talk to somebody different? The prosecutor that was here last time I was here, it was a different,
Oh, you must have talked to Lamar.
yeah,
Well,
yeah, that's what I thought.
It's a state. I'm not gonna be another, it's almost like shopping prosecution. I
Yeah.
can't do that.
I can't
Yeah,
talk to them.
he's no longer employed here. Yeah. Yeah, he's no longer employed with the district attorney's office. Okay. So at this point, what do you want to do?
So I can't talk to any other prosecutor, I can't just.
He's the only prosecutor in this court.
Okay,
Apparently, yeah. I mean, the district attorney's office,
We're the one.
they don't have, they can make an offer. They don't have to make an offer. Okay. So it's not like you have a right to get an offer from the district attorney. It doesn't work like that.
I guess I just hire an attorney,
Okay, so you still want to, okay.
that's my only option, yeah.
Okay, so you're gonna maintain your same option, reset the case to hire your attorney.
Yes.
Okay, we're gonna reset your case 60 days, give you an opportunity to do that. Okay? Please stand on the X in front of the court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. Do we have his paperwork? Is his paperwork? Is it ready?
Yeah, what else?
Yeah. Okay, Mr. Beverly, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? You may put your hand down. Your full name is Jermaine Beverly, is that correct? Now, this is cause number M333180. Case is filed State of Texas versus Jermaine Beverly. Mr. Beverly, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line stating you want to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Engines. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Mr. Beverly, before you signed and initialed all of these documents that I just showed you, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Beverly, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Ms. Perazzo will be given information on how to contact you, and you will be given information on how to contact her. Our court administrator is going to give you that information. Once you get that information, you'll be free to go, and you have a blessed day. Please stand on the far end in front of the court coordinator, court administrator. Here we go. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M332208. Case is styled the state of Texas versus Crystal Marie Brown. Ms. Brown is present in court. Ms. Brown, is your full name Crystal Marie Brown? How you doing, Ms. Brown? You okay? Ms. Brown, you're represented in your case by your attorney, Bruce Smith. However, Attorney Smith is not here. Standing in for Attorney Smith is Attorney Brennan Mitchell. Does Mr. Mitchell have your permission to stand in for Attorney Smith?
Yes, Your Honor.
Okay. Now, the state is represented in this case by Attorney Kobe Hoffpower. Attorney Hoffpower, how are you doing? And Mr. Mitchell, how are you doing?
Great, Judge, thank you.
And we have a representative from Jefferson County Probation Office, Ms. Annette Jones. Ms. Jones, how are you doing?
Fine, Your Honor.
Okay. Ms. Jones, you could come on up.
Yes, sir.
Now, let's see. Let's Mr. Mitchell, I have before me a defendant's motion to modify the terms and conditions of community supervision. Mr. Mitchell, are you ready to proceed?
Yes, Judge.
Mr. Mitchell, you may proceed.
Thank you, Judge.
You're welcome.
On 4/12/23, motion was filed to modify the terms and conditions of community supervision on the state of Texas versus Crystal Brown. We're asking the court to modify the terms that allow Ms. Brown to not have to have the scram device, as we don't believe it's necessary. It wasn't part of their initial agreement. She does have the drug patch. We have adult probation here to talk about the necessity of the scram device. It would also cause 2 issues for Ms. Brown to have that. One would be a financial burden of several $100s a month for it, and the other is it would interfere with her ability to perform her work duties due to the fact the clothing she has to wear at work in one of the chemical plants, and the device interfering with her ability to properly wear protective clothing. May I call Ms. Jones?
Yes.
Ms. Jones, want to state your full name for the record, please?
Annette M. Jones.
Oh, yeah. Would you please raise your right hand? Ms. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Jones, you may put your hand down. You may proceed.
Thank you, Judge. Ms. Jones, you are the adult probation officer for Crystal Brown.
I am.
And how long have you been?
Since she received, how long have I been with probation?
No, just how long have you been over Ms. Brown?
Since April of this year.
And you're aware of the court's order for the scram device.
I am.
In your opinion, as a probation officer, is that a necessity for Ms. Brown that you believe she needs to have?
We've discussed this, and because she has the drug patch, the scram device, she has informed me wouldn't interfere with her employment. I think with the drug patch, some type of monitoring, I don't think the scram device would be necessary, in my opinion.
And she's had other testing done and provided results to you that makes you feel confident that she's clean?
Yes, she had the drug patch installed on April the 17th with an agency in Liberty. I talked with the representative of that agency. She had 2 positives after she first got the patch, but it was because the lady explained to me it did not necessarily indicate she had been using. It could have been environmental, where she worked, other things like that. The last test I got from them was a negative. On the times that she did test positive, she went to an independent agency and had a hair follicle test done. And I think a 12-panel test, even though the drug patch showed positive, those tests, she immediately did that, showed negative both times.
And do you believe those tests are more indicative of whether or not she's been using them, the drug patch itself?
I don't think I have authority or to say that, but because she independently went and had that done immediately after I told her about the positive, I think it indicates that she had not been using and she was trying to prove that. She did it immediately with the hair follicle and with the 12-panel test, and she did that both times. Each time that one was positive, the independent tests were negative.
And you haven't had any other trouble with Ms. Brown?
I have had none.
Is it your recommendation that we not have to have the scram device?
That is my recommendation.
That's what this judge.
Now, let me,
I don't have any questions.
now let me ask you something. You said the positive test, who performed those tests?
The agency that she has,
It's the Liberty County, because I'm familiar with the agency you're talking about in Liberty County. I can't the name, but it's usually by Liberty County, Chambers County, and Jefferson County.
I think it's RMS. I think
believe.
Recovery Monitoring
That's right.
Solutions in Liberty.
That's correct. Yeah. I'm familiar with them. I've worked in all three counties. I'm familiar with that.
So you're saying that when they tested her,
Yes, sir.
at least two tests came back positive.
Yes, sir.
And then immediately after she got news of the positive test,
Yes, sir.
she went to an independent company
Yes, sir.
and they tested it. They did the hair follicle and the 12-panel, and it came back negative.
Yes, sir.
And that was the first time. Second time she went to that company that y'all was speaking of, came back positive. She went back to the independent company, 12-panel, and the hair follicle came back negative.
Yes, sir. Both times.
No, she's not going. She's not going. It's just the device is showing, and then she's immediately going
Yeah,
to get it checked.
Right.
It's not like she's driving to Liberty to have a drug test.
Oh,
That's what you're saying.
It's just the
It's the
patch.
patch.
okay. Oh, so the patch is positive.
Positive because it's monitored through that, right? You understand?
Through sweat.
Through the sweat.
I understand, but I
He
mean,
also works on
Environmental.
but it seems like the patch, is that the,
But what I think, and if I'm just speaking,
Yes.
but she works in a chemical.
I understand.
And for that, the patches.
I know they got all kind of stuff in the air.
But she's
Yeah,
going immediately to get a test that's not the patch and independent and bringing it back to show that
She's not using.
she's not using.
okay, now let me ask you this here. Does she have the patch on? She still have she's required to have the patch, right?
Yes, sir.
And so these are like random tests? Oh, on the patch, do you have to change the patch periodically?
Yes, Your Honor, I do. Every 2 weeks,
Okay.
I go in. If you want to, I have it.
No, I don't need to.
But yes, sir, what they do is they take it off and then they'll send it off. But it's about every 2 weeks, I make the trip to Liberty.
Okay, so they put it on and they take it off.
Yes, sir.
Yes, Judge.
Okay. Let me ask this question. When they take it off, they replace it with another one?
Yes, Your Honor.
Okay. And then they send the one they took off, they send that off. Okay. So she's continually being monitored.
Yes,
Oh,
Judge.
yes, sir.
Okay. Okay, so I guess what you're saying is for her to have the patch and the bracelet is kind of like,
It's
it's overkill. Yeah, I mean, you already have one thing doing, you have one thing that's already monitoring her. And so you don't need to monitor her twice.
Yes,
Because that's what you're saying. So so it's not like if we remove the bracelet, it's not like she will not be monitored.
that's correct. She
Now,
will be
let me ask you this here. What's the purpose of the bracelet?
Well,
I'm just saying, what does the bracelet do?
I think the Scram device is more of a monitored device for alcohol. I'm not-
Okay, and in this case, hers was drugs, it wasn't alcohol.
Right.
Yes, sir.
Right, from I think it was Soma. It wasn't alcohol.
Correct.
Now, she has been supervised in Orange County?
Yes, sir.
Okay. And currently, she's been on probation 2 months of the 6-month probationary period. Is that correct?
Correct. Yes, sir.
Okay. Okay. So, you have anything else?
Nothing further, Judge.
You have anything? Okay. So, that condition, oh man, I'll go to that. Hold on a minute. And since she's been on probation, she hasn't had any problems?
He has had none. She calls me regularly. She's also been monitored randomly, Orange County drug test. She, after the second drug patch test, she went into Orange County on her own and requested that they give her a drug test, which was negative. So I think the discrepancy is the patch is given the results from her sweat. But when she takes a urine test or hair follicle, it's negative. So that's why the agent at the RMS said it could be very possibly from where she works.
The environmental
Yes, sir.
air, getting into the sweat,
Judge,
possible.
I'm familiar with that, and I've also had it happen before on a person who, this is from my experience. Somebody works in the chemical industry, having that happen on a patch. So I've seen that before, not that I'm the expert or anything like that. It is possible, and I think we've seen it before in felony probation.
We appreciate your candor.
Okay, we have anything else? Anybody else?
Nothing further, Judge.
Okay, so the court will grant the motion to remove the I guess the bracelet,
Yes, Judge.
but all other conditions of this probation will be in place. Now, I see, I'm looking at our order here. The order just says, on this day came to be considered defendant's motion to modify terms and conditions of community supervision of defendant Crystal Brown. It is ordered that defendant's motion to modify terms and conditions of community supervision be in all things granted. I mean, it's not really specific.
To the
Yeah.
request to remove all we have to do, Judge, is to write in on it specifically the removal.
Could y'all send us another one?
I got you.
Basically,
What I'll do is I'll have it specifically to whatever
That-
number that is in the order.
I think
The
it's,
original.
right,
I think it's D on the
Is
order.
it D? Okay.
it's, hold on a
And I
minute.
can have my office redraft that and resubmit it for signature.
Okay. Okay, let's see, it's,
And I think that we need to give them the form that we have for the removal. Like, we have a form for removal of this to bring it to, or whatever. Like we would interlock just on the court order along with it.
I think if we just have the order.
That's
same-
fine with it.
oh, the order, yeah,
Unless there's an extra one. That's, it's out of the bundle to come on.
Yeah.
Somebody,
it's,
not him.
He never had it in,
Okay.
so we're good.
'Cause I think once we got it, we filed the motion to modify it, so.
well, they filed 7 days, they filed the week after the, yeah, that's, yeah, condition D. Obtain alcohol/drug monitoring bracelet until further directed. Adhere to program directives and pay all, okay. So it's that, so if you could, we could track that language.
Yes, Judge.
Yeah. Okay. Okay, that's the order of the court.
All right,
All right,
thank you, Judge.
all right, you're welcome. All right, yeah. Okay, and Ms. Brown, just continue to adhere to the terms and conditions of your probation. I tell people this all the time, the road to recovery is not a sprint, it's a marathon. And so with that in mind, you understand that a sprint is a short race, a marathon is a long race. You may get tired along the way, but if you get tired along the way, there are people that you can lean on for support. I think we have someone here who's with you here today.
My mother.
Your mother, okay. You can lean on her. You can lean on the probation office and anybody else that is trying to assist you in your road to recovery. Okay, and you just take it one day at a time. You know, and you know, just like this here, when you take it one day at a time, you're going to get stronger each day. Okay, every day you're getting a little stronger. Okay, you can't see it all at one time, but every day you're getting a little bit stronger. And then once we get a month from now, a year from now, you're going to be a lot stronger than you are today. All right, so just continue to keep up the good work. And well, I pray that you fully recover and you'll be a blessing, not only to yourself, but you'll be a blessing to our society. And most of all, you'll be a blessing to your family. All right, you have a blessed day. You're welcome.
Your Honor, I've got another just housekeeping matter. For Monday, I'm set for trial on Macario Perez.
Okay,
The state has filed a motion for continuance. We are not opposed to it whatsoever.
okay, Perez, okay.
So I just want to make sure that my client and myself don't need to be here on Monday.
Okay, well, if we got the motion, we had a motion?
We have a motion. We filed a motion.
We don't object to it. Judge.
Okay, so we'll have,
In Orange County, Judge.
yeah, she'll print it off. You don't object to it, we'll sign it.
Okay, perfect.
Yes.
The trial docket is set for Monday.
Yeah, Perez.
It's two names, so
I'm set for trial and
it's Marino or Perez or something. What is it?
Macario Perez.
Mario Perez.
Thanks a lot, Ms. Kim. That's it.
Yeah, on Monday.